Unconstitutional remedies or judicial review as under Article 32 of the Fundamental Rights as enshrined under Part 3 of the Constitution. Already we have finished 7 selected headings. Why the very analysis and explanation of the decisions of apex court regarding those different 7 heads. So in this video we will discuss the 8th number that we have selected, and it is regarding public interest litigation and judicial review. So, in that connection, we would like to discuss certain important leading case such as Dr. D.C. Wada versus State of Bihar. In 1987, it was raised that the development of public interest litigation during the last decade has largely modified or modified the traditional rule as to standing to litigate in constitutional matters. And now we'll go to analyze the second important leading case, and that is relating to Rameshwar Prasad versus Union of India, and it was decided in 2006 by the apex court in relation to public interest litigation. So, as it was observed by the apex court, public interest litigation cannot be entertained where stand taken was contrary to stand taken by those who are affected by any action. So, also, we'll discuss another important leading case in regards to that, and that is Sajdev versus Union of India in 1966, also State of Punjab versus Sahil Sablo in 2013 by the Supreme Court. So, in the particularly in the case of State of Punjab versus Sahil Sablo in 2013, it was the observation of the Supreme Court is that a PIL challenging appointment of the chairperson of Public Service Commission is maintainable both for the issuance of a writ of quo warranto and for a writ of declaration as it was declared by our apex court in this particular important leading case. And in that connection also we would like to discuss another important leading case, and that is Ayub Khan, Noor Khan, Pathan versus State of Maharashtra in 2013. The apex court declared filing a PIL in service matters is not permissible. And now we'll go to another important leading case, and that is Jaideep Mukherjee versus State of West Bengal in 2011. The Supreme Court observed that the jurisdiction of Supreme Court in public interest litigation cannot be placed into service where the matters have been completely and effectively adjudicated upon in the individual petitions and also in the writ petitions, raising larger questions as it was observed by the apex court in this particular leading case, Jadip Mukherjee versus State of Bengal in 2011. And now we'll go to another important leading case, and that is relating to Arun Kumar Agrawal versus Union of India in 2014. The Supreme Court expressed that a PIL would not be maintainable where it is filed at behest of some powerful business houses. And another important leading case relating to public interest litigation that will discuss state of Uttaranchal versus Balwant Singh in 2010. Supreme Court made the observation that the prevention petition by a practicing lawyer challenging the appointment of Advocate General on ground that appointee was beyond 62 years of age amounts to of misuse of PIL or public interest litigation, as law in this respect is already settled, as it was the observation made by the Supreme Court in relation to misuse of PIL. So now we'll go to another facet, that is relating to those writs, and regarding the writs, as already we have discussed in length and in detail about all these five writs like habeas corpus, mandamus, certiorari, prohibition, quo warranto, when we were discussing about administrative law. In our uploaded videos, we have already uploaded each separate video on each writs, such as habeas corpus, mandamus, certiorari, prohibition, and quo warranto. So, it is our request to our viewers to refer all our previous uploaded videos separately on each writs that already made in our subject relating to administrative law. So here only we will touch some other aspects regarding such writs that we have left. So in regards to habeas corpus, we will discuss the first one is Umu Shabina versus State of Kerala in 2011. Supreme Court made this observation that the most effective way of doing the duty to safeguard the liberty not only of the citizen but also the persons within the territory of India is by exercising the power by the court by issuing a writ of habeas corpus safeguarding the liberty. And in the second important leading case, Gopal Das versus Union of India in 2011, Supreme Court expressed that the Supreme Court cannot give any direction to the Pakistani authorities as it has no jurisdiction over them, as it was decided in this important leading case, Gopal Das versus Union of India. And now we'll go to another important leading case relating to habeas corpus, and that is Indian, and that is relating to Abdul Nasser Adam Ismail versus State of Maharashtra. In 2013, Supreme Court expressed that the very writ of habeas corpus petition cannot be dismissed on the ground of imperfect pleadings. And now we'll go to another important case relating to habeas corpus. Remedies Manu Bhai Ratilal Patel versus State of Gujarat in 2013, the apex court observed that a writ of habeas corpus is not to be entertained when a person is committed to judicial custody or police custody by the competent court by an order with prima facie does not appear to be without jurisdiction or passed in an absolutely mechanical manner or wholly illegal. And now we'll go to another important leading case that is relating to the writ of habeas corpus is Kishore Samriti versus State of Uttar Pradesh. In 2013, the Supreme Court observed that a petition of habeas corpus lies against the authority, even the executive authority, as well as against the private individuals. So, after this observation, we would like to discuss another important leading case, and that is also relating to habeas corpus. So, in regards to that, we will discuss one important leading case, and that is the leading case of Gracie versus State of Kerala, and it was decided in 1991 by the Supreme Court, where it was expressed that in case of preventive detention, main ground of interference is breach of Article 22, Clause 5, as it was decided by the apex court in this leading case, Gracie versus State of Kerala. And now we'll go to another important leading case, and that is relating to Nilavati Behra versus State of Odisha. In 1993, the Supreme Court expressed that compensation may be awarded for death in police custody. And another one important leading case that is falling under the writ of habeas corpus is Nitya Anand Raghavan versus the State of National Capital Territory of Delhi in 2017, Supreme Court observed that habeas corpus cannot be used for mere enforcement of order passed by foreign court, as it was decided in this important leading case, Nitya Anand Raghavan versus State of National Capital Territory of Delhi in 2017. And now we'll go to the second most important read, and that is Madamus, which we have selected under the head, that is number 10, where we would like to discuss exactly the very amplification and interpretation and its application of this writ mandamus in the particular leading case, Dr. Pramod Kumar Joshi versus Municipal Medical Council of India. So, in this particular leading case, Dr. Pramod Kumar Joshi versus Medical Council of India in 1991, Supreme Court made this observation that mandamus should be issued under Article 32 where a fundamental right is infringed by a statute or by statutory order or by executive order which is non-statutory, as it was observed in this leading case and in another relating leading case. In relation to the writ of mandamus is K. Vijayalakshmi versus State of Andhra Pradesh, decided in 2013 by the Supreme Court, where it was observed that no mandamus can be issued for appointment where a person was wrongly denied for appointment. And now we'll go to another important leading case, and that is relating to mandamus, and that is Union of India versus Namit Sharma. In 2014, Supreme Court made the observation that no mandamus can be issued to the rule-making authority to make the rules either within a specific time or in a particular manner, as it was decided in this important leading case by the Supreme Court, Union of India versus Namit Sharma. And now we'll go to another important leading case, and that is relating to the writ of mandamus, and that is the leading case Beneath Narayan versus Union of India. So, in that particular leading case, Beneath Narayan versus Union of India in 1988, Supreme Court made the observation that where the mere issue of one-time mandamus would be futile against a public agency guilty of continuous inertia, then continuing mandamus can be issued. And it is one of the important pronouncement of Supreme Court regarding continuing mandamus. And now we'll go to the next important leading case, and that is relating to the Committee for Chakma Refugees of the Chakma of Arunachal Pradesh versus State of Arunachal Pradesh in 2015 Supreme Court observed as regarding mandamus, the Chakmas has a right of citizenship in Arunachal Pradesh. They cannot be required to obtain any inner line permit as they are settled in the state. So, in this video, we have discussed those headings that we made. One is PIL, Public Interest Litigation and Judicial Review, and the writ of habeas corpus and mandamus. So, in our upcoming video, we would like to discuss the other heads that we have selected, such as the writ of certiorari, the writ of quo warranto, and the very interpretation of writ jurisdiction and the limits of writ jurisdiction, and so also legislative enactment and writ jurisdiction, and that we would like to discuss in our upcoming